As said from my intro, tonight is another opportunity for us to have the Legal Hour Show, proudly sponsored by CITI Law Solicitors. So tonight, I'll do what I always do, bringing to you the law. I'm going to look at immigration tonight. As I said from my intro, we discuss various areas of law on this platform. We do this program, if it is the first time you are joining us, we do this program every Tuesday from 9:30 onwards or 9 o'clock onwards. And every Thursday, the same time from 9 p.m. Onwards. And we discuss various areas of the law. Tonight I'm looking at immigration. Particularly, I'm looking at those of you with limited leave to remain, how you can bring other children to the UK. So I'm going to look at this in a very broad manner, so that I can cover even those with Appendix EU, limited leave to remain. So that every one of you who fits into what I'm going to discuss or have the benefit of this advice and rely upon it to bring your son or the family member, whomever you want to, that person to join you in the UK. So that's what I'm going to do tonight. But before I do that, I want to urge you, if you are watching, to share the video so that your family members, including those who would want to benefit from this free legal advice, to also watch. Now, this program is being broadcast on 3 main platforms. The program is being broadcast on CITI Media TV. My own personal profile, both on Facebook, Thomas Berbel on Facebook. And then we have CITI Law Solicitors YouTube channel, where you can also watch this program. And then we have the CITI Media Radio, Modern Ghana. So you have no excuse to miss this show tonight. And it's full packed with advice that will assist you to understand the immigration rules with respect to Appendix FM and how those with limited leave to remain can bring their children to the UK. That's what I'm going to do tonight. I will be dissecting the immigration rules, looking at various areas under these immigration rules, including Article 8, which encompasses family life and private life. So I'll be looking at all these areas tonight. As I always do, I'm going to go on a short commercial break. When I come back, I'm going to continue the show. And at this point, once I have finished within a matter of 20 minutes, I will allow viewers to ask questions. If you have any legal question, this will be your opportunity to obtain free legal advice. So please don't go away as I go on this short commercial break. Hello everyone, thank you so much for your patience. As I said, tonight I'm going to take my time to give free legal advice. As I always do, this platform, we teach the law. We make sure that viewers have the benefit of understanding what is happening around them, whether it's employment law, whether it's immigration, whether it's personal injury, whether it's civil litigation, disputes. So tonight I want to urge you to please join me and let's have this discussion. Because if this does not concern you, it might concern a family member. So why don't you invite that family member to join the show tonight? Because this is the only place that I provide this free legal advice. As MC Chaka said last time, if you come to the office, then of course you're going to pay for consultation. But on this platform, I give this free of charge. This is part of our corporate social responsibility to the public. So tonight, you will bear with me whilst I take my time to explain a few things to viewers concerning how they can assist in making their children join them, irrespective of the leave to remain that they have, because people have various bases for living in the UK. Some are British, some have indefinite leave to remain. Previously, some used to have permanent residence. Now they have settled status, which is also indefinite leave to remain. Some have limited leave to remain under the Venice EU. Some have limited leave to remain under the immigration rules. Some even have student visas, independent. Some have skilled worker visas. So all these categories of visas are available to parents. But the point is that how will a parent falling under any of these categories be able to bring their child or even a family member to the UK? And that's what I'm going to look at tonight. So please, before I do that, I can see that most times by the time I come to the end of the show, I don't get the opportunity to acknowledge viewers. So this time I want to acknowledge viewers as I go along. So if you have just joined, I have Kwesi Nanache who is watching tonight. I have Nana Frima, our regular favorite member of this show. I have Nasiru Lamidi Bonaribe Saba. I have Don Bolas. Don Bolas looks like a new person that I've seen on this platform. Thank you so much for watching tonight. I have Honorable Isaac Osei Isaacs, who is also watching. I have Ania Uwa. Ania Uwa sounds like an Anyine, who is also watching tonight. I have Tina Tamaklu. Wow, great. How are you doing, Tamaklu? I have Nana Ajwa Mosiah. I'll say hello, everyone. And then Nana Frima. So guys, thank you so much for being there. So tonight, as I've said, I'm going to discuss immigration. I'm taking my time to explain stuff to viewers. And at the end of this show, I'm going to allow viewers to ask questions. So if you have anybody who has a question, you can ask that person to join the program. When I open the phone lines, you can phone in. If you want to type your question as I go along, I will also make sure that I can answer your question. I always say that I am not a doctor, so I can't give you medication, nor a pharmacist to give prescription. I am not a family mediator, so I cannot assist when you're having challenges. But there is one thing for sure, I know the law, and tonight I'm here to share my knowledge with you. So let's start with what is the topic of tonight. The topic for tonight is how people can bring their children to join them in the UK. So first I want to look at what you mean by a child. And then from there, I also look at the parents and the various leave that they have that allows them for these children to join them. And then I'll go deeper into looking at Article 8 of the European Convention on Human Rights, and then balance it with the public interest test. So you see, it's four-packed. But I want viewers to take their time to follow me quite attentively. Because I say that bringing a child to the UK, unlike the United States of America, is the most difficult and complex. It is an area that we see about 80% refusals, and most cases end in the tribunal. And the reason why most of these cases end in the tribunal, and even after those cases have ended in the tribunal, some are not even successful. Because when you start the application, there are requirements to satisfy. And normally for entry clearance applications, the judge has the power to look at documents that were before the entry clearance officer, which is when you make your application, whoever is going to make decision on that application. Or most importantly, if you put in a plea and then the entry clearance manager was to review it under the current dispensation, then those documents that you put there, it will surprise you that if that stage passed, that sometimes there are other documents, either the Home Office can oppose that document being relied upon because it was not before the entry clearance manager or the officer, or you might not be permitted to rely upon it. So you see why the start of the application is so important. So now, let's look at who a child is. When we say a child under the immigration rules, we are looking at those who are under the age of 18 years. That is the definition within the Appendix FM and S1. But again, if you look at, I said talk about the EU law, because even though we have left the EU, we still have the Appendix EU of the immigration rules being operational. And as the Home Secretary, Priti Patel, made pronouncement, quite formidable announcement, in December 2021, she said, and I quote, "The settlement scheme will be there indefinitely." So it means that people who met the requirement before December 2020 will still continue to do so and will still be eligible to make applications. So it means that I have to define a child under the European regulations or Appendix EU of the immigration rules. And under the circumstances, the child is somebody who is under the age of 21. So you see there is a slight distinction between a child under the immigration rules and then a child under the Appendix EU of the immigration rules. One comes all the way to the age of 18. The other comes all the way to the age of 21, which most cases you will say is an adult. But under the EU law, that person is still a child. So this is the definition of a child, either looking at the immigration rules or looking at Appendix EU of the immigration rules. But having defined who a child is, which people are eligible to allow their children to join them in the UK. Obviously, if you're a student, everyone knows that you can come here with your child and your partner or dependent. If you are on a skilled visa, possibly, most times, these employers may put it in your condition of employment because you are coming here to work and the child might pose a restriction on your working conditions in the sense that you might not devote your time fully to the work for which you are coming here. So other than that, they are equally eligible. But this is something that needs to be discussed with the employer in order to embark on that. But having said that, so this category of visas allows children under the 18 to also come in. But I'm going to look at other distinct areas. So the other most common area is somebody who is also a spouse of another person who is either British or a Solicitors. So that person also has the right to bring a child under the age of 18. So I'm taking my time to describe all the categories of visas that parents may have that allow them to bring their children. Then I will go into the next stage where I'll be looking at if you have that leave to remain, though you are eligible to bring a child, it's not an automatic. And that's when I will reveal the secret why most of these applications are refused and they are also unsuccessful in the immigration tribunal. So I've looked at those students, I've looked at the skilled workers, I've looked at spouses or partners who husband or wife might either be a British or have an indefinite leave to remain, who are also allowed, are permitted to come along with their children, or once they are here on their limited leave to remain for their children, to join them in the UK. And everybody knows that if you have indefinite leave to remain, of course, that also allows you to bring your child in the UK to the UK. So these are common areas that everybody is almost always familiar with. The most distinctive aspect that sometimes people are not familiar with is those with limited leave to remain. Now, you realize that in this country, most people have this limited leave to remain because after they've come to the UK, they were fortunate to conceive and have a baby whose father either has indefinite leave to remain or who has a British passport, and a child becomes automatically British, and therefore the mother relies on it to make application for that mother to then get leave to remain either on the 10-year route or the 5-year route as a parent. But obviously it's not just mothers who do that. If you also came in with a visit visa and then you met someone here, you had relationship with a person or whatever it is, you became a father, and that mother has a certain status or indefinite leave to remain or a British, then your child becomes automatic British. Then you as a man can also make application to become somebody who is a parent of that child, British child. And therefore you'll be able to also get limited leave to remain under the parent route. So you see that mothers are able to do that, fathers are also able to do that. But within this same category, there are those who probably came on a visit or whatever reason they came here with a child who was perhaps age of 1, 2, 3 or whatever. And then they stayed here for 7 years. And after they have stayed here for 7 years, that child is still under the age of 18. They can also apply under the general or the exceptions. And then they will also get leave to remain on the basis of the child having been here for 7 years. So you see, I have created distinction of 3 parents who say have limited leave to remain because of the parent route. Of course, I know that those who have also lived here continuously for 20 years may are also eligible to have limited leave to remain. But of course, by the time you are here for 20 years, your child will probably have become an adult. So I'm not going to talk about those people tonight. I'm just talking about these 3 categories of people. So having described these parents with this limited leave to remain issued under the immigration rules, how then are they able to bring their children to the UK? This is where I'm going to take my time to explain, because this is where most of the refusal occur, and I am going to take my time to obviously explain quite in detail, and then after I've done that, I'll give you the chance to ask questions. Again, as I want to continue to acknowledge those who have joined. I have Gifty Abla Nyanze, sorry for not getting your name right, who has also joined us. I have Nasiru Lamidi, said glad to be in the right place to find solutions for my issues. Great. This is the Solution Center. I have Clement Ajiman, who is also watching here tonight. I have highly favored Priscilla watching. I have Cynthia Ankama, who is watching here. I have Rafu Frimpon, who is also watching. Abigail Asare watching tonight. Gabriel Bankori watching. He's a good evening lawyer. And I have SHA1, who is also watching tonight. Thank you guys for joining. Great. So if you have just joined tonight I'm looking at immigration. I'm looking at those with limited leave to remain. I have given general description of the kind of leave parents have, that they are able to rely upon it to bring their children to the UK. And I've gotten to the point where I'm looking at those with limited leave to remain issue under the immigration rules. I have briefly looked at those with limited leave remain or pre-settled status issued under the Appendix EU of the immigration rules, which is quite common for people. But I'm looking at this unique area. So these categories of limited leave that I've just described, for example, a mother who had a British child and made application on the parent route, or a father who had a British child who made application on the parent route, or a mother or father who was here with a younger child who had been here for 7 years and under the age of 18 who has applied for limited leave to remain. How those people can also bring their children to the UK. Of course, everyone knows that if you have indefinite leave to remain, it's a common phenomenon that you end up bringing your child. But of course, I'm going to take my time to also explain why most of those applications I refuse. So if you are still here with an indefinite leave to remain and you are watching me, it's not a wasted time, because in the end, you still need to understand, because we have a lot of people who have indefinite leave to remain and they want to bring their children to the UK, and those applications are refused. And sometimes you go to the tribunal, the cases are also dismissed. So we need to learn to avoid these pitfalls. Yes. So let's take it that you are a father on the parent route and you have other children who are also living abroad. You came here, you had a child here. That child, as a result of which you then made application and had 2.5 or either on the 5-year route or 10-year route as a parent of that child. Or your child has been here for 7 years, and for that reason you're on the parent route as a father. So I'm looking at fathers first. And then you have other children who are also living abroad, maybe Ghana or any part of the world, that you also want them to join you. Now, most times people are of the erroneous impression that they don't satisfy the eligibility to bring their children from abroad because of the nature of the leave they have, which is the leave to remain, which is the limited leave to remain. But if you look at the immigration rules upon the FM, the provisions are quite clear. The exceptions and the general true one all set out clearly how people can bring their children, if you're a father and you have other children abroad, how you can bring them here. And if by converse you are also a mother, the same circumstances where you have a child here and you have some of your other children abroad and you are on limited leave to remain as a parent, then you are equal. If you look at the Appendix FM of the immigration rules, the general and then the exceptions, to be precise 2.1 onwards, it says out clearly that you can also bring your children to the UK. Somebody was just discussing with me, and then it was quoting the law 297. I said, look, this one applies to only those who have indefinite leave to remain. So if you are relying on this to make an application, the entry clearance officer may be mocking you whilst refusing your application because he knows that you don't know the law, because you are relying on the wrong law to make the right application. And that's why we take some of these things. I know it's a bit technical, but those of you who are following attentively, I'm sure you understand what I'm talking about. Right. So, as a father or as a mother on the limited leave to remain, you are also able to bring your child. But how do you do that? First and foremost, you need to, when you are bringing a child with a limited, if you have limited leave to remain, there is no requirement for you to satisfy financial requirement. And when I say financial requirement, is when, especially if you are bringing your spouse or your spouse with children or with a child, then you are supposed to show that you are earning 18,600 and above. Now, if you are bringing just a child with your limited leave to remain, you are on the parent route, 10-year route or 5-year route, you want to bring your other children, there is no requirement to satisfy financial requirement. However, there is what they call maintenance requirement. The maintenance requirement is that you need to show that you are working and at least you earn more than somebody who will be on benefit will be earning. So with that amount, then you can show that you'll be able to feed your child without recourse or resorting to state fund. Because the public interest test, which I will soon come to, takes into account that as well. So that's one of the requirements that you need to satisfy. The second requirement, obviously, is that you need to have sufficient accommodation. So if, for example, you are living in a 2-bedroom and you have one child, normally, depending on the age of that child, 2-bedroom is normally counted as 3 rooms under the housing law. So it means that the living room is counted as one of the rooms. And therefore, if you are a child that is living with you, and in fact, you want to bring even 2 children, depending on their age, if they are under the age of 11 or depending on their sex, then you are also allowed to even bring 2 more children to join you so that you'll be a total of 4 in that 2-bedroom. Provided you understand the law that governs that. Or even if you have 1 bedroom and you want to bring another child and you are living with 1 child, the law says permit that as long as you are not in breach of the housing regulation, which is looking at the sufficient accommodation rules, which is if the child is under the age of 11 and they are of the same sex, then they can share a room and they count the living room as well. So you end up meeting the accommodation requirement and then the maintenance requirement. These 2 requirements are quite essential. But let's see why most of these applications are refused. Normally, you should also have what they call a sole responsibility. But the danger is that if one parent is living here and another parent is living abroad, then it means that the starting position is that responsibility is shared. When I say responsibility is shared, it means that For some of you, you send money to look after your child through the mother or through the father. It means you are sharing that responsibility. And because you are sharing that responsibility, the law does not permit you to bring this child to the UK, because the child was born abroad. The child has lived all his or her life there. He is comfortable, and in fact, his lifestyle is enhanced by you sending money to the mother or the father to look after the child. So the question that they will be asking you, why do you want to approve this child who has lived in this community with friends and other family members to come to the UK to start a new life? And I know that this sounds crazy, but that is how the immigration rules has been molded or have been legislated, saying that if parental responsibility is shared, then it becomes almost impossible to bring this child to the UK. And the point is that as long as one parent is living abroad, the starting position is that responsibility is shared. So you need to be able to prove that you have sole responsibility of that child. So it means that you having limited leave to remain, it is not what is preventing you from bringing your child to the UK who is under the age of 18. But rather, it is you showing that you have full control and take all the major decisions about that child. That is what may prevent you. Then it means that by extension, it doesn't matter whether you have indefinite leave to remain. If you are sharing responsibility with either of the parents abroad, then you also have this hurdle. You face this challenge, this difficulty of also bringing your child to the UK. So you see how this becomes so complex. How do you then prove that, look, I am the one that takes care of this child? But yes, you are the one that takes care of this child, but somebody else is also playing a role in his or her life, and that person is a parent, one of the parents. So there is always that difficult conundrum for people to be able to prove that in fact, though they are abroad and sending money, but in fact, they take full control and all the decisions about this child's life. But sometimes this might not work because of what I've explained. So what options do you then have? This is the part that most people take it for granted. But it is the part that when you rely upon it, then either the entry clearance officer will be forced to issue the visa to you, or even if you go to the immigration tribunal, the judge will be forced to allow your case. And this is the secret why CITI law solicitors, most of the applications that represent parents who want to bring their children, we end up succeeding and making sure that these children get their peace allowed when parents have decided to do it on their own and they have made a little mess, and then they're now looking for a solution from us. It is the European Convention on Human Rights. If that child lived abroad, you have your leave to remain, you have visited a child a couple of times, you've taken pictures with a child, you've been involved in that child's life at any stage that you've been abroad, then technically you have formed a family life with that child. Because you've gone, so viewers should take note of this. There is one thing having sole responsibility by sending money and taking all the decisions about a child's life. And another, also having a family life with that child. The two are distinct and mutually exclusive. So if you rely on one and that one fails, you might rely on the second and you might succeed. So it means that there are people who, for very strange reason, they've never gone abroad. And even lawyers sometimes tend to conflate this. They don't create the distinction because the two are mutually exclusive. And therefore, if you conflate it, what I mean is that if you confuse the two, then it means that you expose yourself to the caseworker or the entry clearance officer or the judge who probably knows it, but it is not for him to fight the case for you. You, as a lawyer, need to fight that case. Then it gives them the opportunity to read it out and dismiss these cases. Because one can stay in the UK and continue to look after the child abroad, and perhaps for one reason or the other, he had never had opportunity, maybe because of financial reason, to travel abroad to go and see that child. But that parent here, according to the well-established KTG Yemen, can claim sole responsibility by those decisions he takes over the phone, by the funds he sends to that child, by being involved in how the child goes to school, the hospitals the child attends, the churches, those, even all the stuff that the child does. He's here, but he's in charge of those things through the phone. And sometimes even send money to look after that child. So that parent is building a case of having sole responsibility, which is a very strong ground for bringing the child to the UK. And by showing that that parental responsibility is not shared with the other parent who is also living abroad. But if that fails, because some people, because they have funds back home, they don't send any money. They don't have any evidence. They don't have record of sending money. They don't have record of even speaking to the child, because sometimes they talk to them over the phone. We have case laws that when we are dealing with cases, the mere fact that you can state that you are speaking to the child over the phone, there are cases that support this. Not all the time that you need to get write-up evidence, documentary evidence, something that is recorded. Because these days people make phone calls or they make internet calls and they might not have record of it. But there are case laws, but I'm not going to go through into case laws because tonight I'm just explaining this these parents who have limited leave to remain who wants to bring children. That is what my focus. So I don't want to bore you with case laws and laws. But having said that, by discussing the sole responsibility, if you visited a child a couple of times, you have pictures, you have all the evidence to show that you have, anytime you are abroad, you are involved in a child's life, then you are saying that, look, apart from having this sole responsibility, or even if I don't have it, when I have had my papers, I have visited my child, I've gone there a couple of times, I've been involved in a child's life. Each time I'm there, we do things together. These are the documentary evidence to show that we've been doing all these things together, and I have pictures to prove it. Then it means that the UK, under the European Convention on Human Rights, if they don't allow this child to join you in the UK, it means that they are breaching the convention. Because everyone, according to the Article 8, have a right to family life and private life. And that child is part of your family. Not because he's your child, but because of the bond that you have suddenly had with that child by visiting that child abroad a couple of times. So it means that you can form the family life even after not seeing this child for 10 years or 12 years. Suddenly, you can create that bond. This is deep law. So once you've created that family life by having physical contact with that child, then it becomes very difficult for one to say that, oh, you will not be granted the visa because you've lived all your life, which is what they normally put it down as a template in, you've lived all your life abroad and your parents have been living in the UK and blah, 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 blah. No. Once that visit has taken place, one or twice, evidence of it, family life has been created, quite strong grounds. But of course, there are other reasons where there might be compassionate reasons. Looking at, so I'm now moving straight away to my third option, which is one of the, so it means that you can combine all these three. I'm going to talk about the third one. You can combine all these, because I said that they are mutually exclusive, but you need to extract the distinction to make it clear to the entry clearance officer or the judge whom you are before him that this is the case I'm relying on, and these are the distinctions that I'm creating. So if this one is failing because my leg is weak on this point, I have a strong ground here to bring that child here because of these reasons. So the third grounds is what I will normally call the compassionate grounds, or compelling, what they will say, compelling circumstances. It could mean, normally if one parent has passed away, then automatically the other parent has sole responsibility. So it makes life quite easier, because there's a sad story behind it. One parent has already passed away. However, children being abroad may also find themselves in a very compelling circumstance where, for example, whoever they are living with is moving abroad, or where, for example, something has happened to the child, maybe the child has been raped, or something has happened. Something has happened to this child, because if you look at the Borders Act, Section 55, the United Kingdom, again, under its own laws, have a duty to promote the welfare of every child. That duty is law. It's enshrined in law. So it means that if I'm relying on my compassionate circumstances of this child, then I need to trigger the Section 55 to make it clear that, look, you cannot ignore the circumstances of this child, because you are bound by law under Section 55 to allow this child to join me. And if you don't do that, you are breaching this law, which makes it unlawful. And if this case was to be before a judge in the immigration tribunal, again, it's another solid ground for you to be successful in this case. If the entry clearance officer is minded, what they do most times, to issue this application. So you see, I am building a case for viewers, dissecting the areas, not conflicting all the three. It's not just putting stuff out there. It's about making it clear what grounds you are relying on. And in fact, creating that distinction that, look, if this one is failing, this one is working. If these two fail, this third one should work. And that is the grounds upon which you, with limited leave to remain, can bring your child from abroad. So you see, I have taken my time to gradually explain to viewers why most of these applications are refused. Because those of you either making these applications or even taking these matters to tribunal may not be in a position to create these mutually exclusive grounds to ensure that there is always a second strategy. And I am not sitting here bragging, but I know that most of you watching us, some of whom we have represented, are people who have given testimonies, how we have represented their children who they want to bring from abroad, and will be successful in winning the case at the immigration tribunal. Not once, many times. It is the law. So tonight it's been a privilege being here with you, discussing the law, which I'm so passionate about, and the team of CITI Law Solicitors are willing to provide that assistance. So at this point, I'm going to acknowledge the viewers, and then I'll open the phone lines, I'll also take opportunity to tell you what CITI Law Solicitors does. So whilst I'm doing that, if anybody has any question, you can ask your question. I will put in the phone lines out there, opportunity for you to ask a question. You can also type it, and I'll be willing to answer. I have viewers who have also joined. I have Emmanuel C watching. I have Thomas C, my own cousin, Bonarwe, Sava, Thomas. I have Pa Kofi Pizarro, who has been a regular member. He's also, we have John Obri Yeboah, I think all the way from Ghana, join us. I have Level Gilbert, good evening lawyer. Keep on doing the good work. Please, if you are in the UK with your wife and you want to bring your 2 children under 4 years, what are the requirements? Well, if you are in the UK with your wife, well, Gilbert, if you are in the UK with your wife, it's not the. It's a very broad question. It is the nature of the visa that you have. I have spoken about the student, so perhaps you have the student route. If it's a student route, then you need to meet the maintenance requirement. And of course, if you meet the maintenance requirement, and you can show that that child is your child, then of course you are able to bring that child. Those of you with limited leave to remain, I have just taken my time to explain the reason why those of you who are students or skilled workers and all that, when you are coming or you be here for just a short time and you are bringing your children, it's so easy for you. You know why? It's because you're already living with those children abroad. You have a family life with them. So you have the right to come with them to the UK. And again, you also have sole responsibility with them, or joint responsibility. For example, somebody like Gilbert who is here with a wife, it means that there is nobody out there to look after those children. So he has a right to bring them here to look after them. Remember when I was doing my discussion, I said that when responsibility is shared under the immigration rule, then there is a problem. But of course, I think Gilbert's route might fall under the student route, which is the maintenance requirement that he needs to satisfy in order to bring those children. I have Abeku Ham watching. Abeku, I think I have, Sophia Ashong. How are you, Miss Ashong? It's been nice seeing you once again and again and again. I have Teka Okpa Edwards watching all the way from Nigeria. If I have mixed anybody, please, if you put a comment out there, I'm going to be able to acknowledge you. I love acknowledge all those who are on the platform because I feel thrilled that you create time to join us to have this discussion day in, day out on Tuesdays and Thursdays. And I'm so grateful for the time. I know how busy it is in the UK. For one to create a time and join the program, he deserves to be thanked. But at least, the only thing you can take out from here is that this is where we teach the law. Yes, so those of you who have just joined, I have said that I have looked at those with limited leave to remain, how they can bring their children under 18. I have taken my time to explain what the sole responsibility is, what the compassionate grounds is, and above all, the human right, the European Convention on Human Rights, how that is a strong weapon in the weaponry of any sponsor who wants to bring their child from abroad. And don't lose that contact because you might not have that sole responsibility if you leave it for too long. And that's why I was focusing on those who have limited leave to remain. Most people are of the view that if they don't wait until they get indefinite leave to remain, they can't bring their children. I want to disabuse your mind of that. Because if you leave your child for too long, two things could happen. Recently, a couple of months ago, this year, if I'm right, our team, me and my other colleagues in the office, we dealt with a case. And by the time we finished the hearing in the tribunal, I think the child is about 19, almost more than 19 years. This is a parent that he's been our client. Obviously, he had opportunity to have brought this child to the UK, or this children to the UK, when he was on the limited leave or had residence card or whatever. But for whatever reason, she didn't do it. Most times, the judges are very concerned, and the immigration rule itself doesn't support the fact that you leave your child abroad for many years, or under the misguided or misconception that you are not eligible to bring them because you have limited leave to remain. This is what I've been discussing tonight. So that case that we did, even though we've been dealing with the tribunal, there's a lot of things that I learned that day, because the judge was very, very concerned. Why have you not brought your child all this while? And even recently, another case, I think it also came up. So that's why I'm taking my time to educate viewers that don't leave your child abroad for too long. Because by the time you get your indefinite leave to remain, it might almost be impossible. Because this case we dealt with, thank God, his prayer work and our effort also supported him. And the child, even though being more than 19 years, the girl is now in the UK, which is good. But it was a struggle, because he could have done this earlier. He didn't do it, But obviously, with him having visited the child, human right grounds, the application was put in. In fact, I put in the application, and at the time I was putting the application, I told the parent that this application is likely to be refused. But give us distance. When it's refused, we'll go to the tribunal and we'll win this case for you. And lo and behold, the application was refused. We went to the tribunal, the child was almost 19, and we won the case for the gentleman. But the point I'm creating here, or I'm trying to establish here, is that with your limited leave to remain, you have the opportunity to bring your child if you have an intention of doing so. So don't wait until you get indefinite leave to remain, because by that time, either the child has become an adult, or you don't have sole responsibility, or you have not even been visiting this child, so there is no human right grounds, or there is no compassionate circumstances, because a child that is almost 19, that duty to protect the best interests of children under Section 55 will not hold. So we see the challenge people go through by not taking advantage of the moment when they have limited leave to remain to bring these children to join them. And then they want to do so when they have their indefinite leave to remain. So that's what I've been trying to explain to viewers tonight. So the phone lines are open. If you have any question, if you have anything you want to say, if you have any contribution, I give you the opportunity to do that. But while doing so, oh wow, I intended to finish 10:30 tonight, and I'm a little bit, I'm just going to take opportunity to advertise CITI Law Solicitors, and then I'll be off. So whilst I'm doing that, if you have any question you want to ask, the phone lines are open. It's 0793 293 4518. I repeat, 0793 293 4518. That is one of the studio numbers. The second studio number is 0444. That's 0744. 033 8623. I repeat, 0744 033 8623. That is the second studio number. Please don't call this number when I've left the studio. Rather, this is the number to call. This is the office number. You can always get us on this number. For those of you calling from abroad, the code is 044. And then you can put 2033550782. If you are calling from Ghana, from Nigeria, from America, anywhere apart from the UK, it's 0044 2033550782. If you are calling from the UK, the office number is 02033550782. If you want to visit us for whatever reason you want your matter to be private and have confidential discussion in a secured consultation room where your privacy can be protected, you can come to our office, Unit 113 and 122, Barking Enterprise Center, 50 Cambridge Road, Barking, IG 118FJ. That is the office address. It's very close to the Barking train station. I always say that if you get there and you're hungry, there is a KFC there, you just jump in, have a plate of chicken, and then after you come out of the KFC, you just turn right at the zebra crossing. You walk for just 30 seconds, you see that building, Barking Enterprise Center. That's where you can find us. It's not an obscure place. It's on the Cambridge Road. Come out of the station, turn right, and then turn right again. Don't go down, just turn right. Walk for 60 seconds, which is a minute, you see the Barking Enterprise Center building. Hello.
Hello, good evening.
Good evening, sir. You don't have to mention your name. If you have any contribution or a question, you can go ahead, please.
Oh, okay, sir. Yeah, I just call thank you for what you are doing for the hard job you are doing for us. Then I'm really happy. Just want to give my testimony for the job you done recently for me about my son.
Hallelujah.
I really
Inshallah.
appreciate it. Yeah,
Good.
I really appreciate it. And I'm very, very happy. And I invite everyone to come, to come, to how do you call it, when they have a program to bring their children to see you, because you do a wonderful job for me that I didn't expect. So I really appreciate it.
Good. Thank you, gentlemen, for
Welcome, sir.
phoning in and spreading the good news. I'm sure viewers will take note of this, and if they have similar problems, they will come to us.
Good, sir. You see, my wife is me and my wife we are watching you.
Wow, interesting.
Yes,
Interesting.
you are doing a good job.
Thank you. That is our joy. Our joy is to win cases for clients to be happy, so that everybody is happy. Yes, thank you. I'm most grateful for also coming on the show to give a testimony. God bless you. Inshallah. Allah Akbar. Allah Akbar.
Thank you.
Yes, viewers, so that's one of the clients that is very happy with the service, because of data protection. I won't go into details, but recently I went to the immigration tribunal. It was quite a complex case, and we won it hands down. This is what CITI also does for clients. So if you have a similar problem, Don't go anywhere. We are here to assist. Right. So I'm quickly going to go through the areas that we specialize, because most people think that we only do immigration. No, we do a lot of areas of law, and we are well versed in all the areas that we practice. Now, so for immigration, somebody have just given testimony. We specialize in all areas of the immigration laws, asylum, the EU, those who want to naturalize or register, any application under immigration rules, spouse, bringing your children, student visas, skilled worker visas, even license. We have obtained numerous licenses for care companies, and we are working with them. Recently, I was talking to one of the care workers owners. He said that one of them made application, and the Home Office visited them. I said, look, all the applications we have done for our clients, because we know what we do, there have never been any visit on their premises. Yet they always give them a rating license. This is what CITI Law Solicitors is doing for those who own the care companies. And I'm sure most of them are watching us, and they know the good job that we are doing for them. CITI Law Solicitors, miracles are always happening here. Okay, that's the immigration aspect. Just to let you know that we do all this business immigration by getting licenses for care workers as well. So if you know anybody who have not yet taken advantage of this opportunity to enable you to bring people from abroad, we do this license for them, and then we also do the visa applications. Recently, we did visa applications for a lot of some of the candidates that are coming. Not even one of them had a single problem. So we do all these applications. You know, I know some of them did some of the applications, even though they have the skilled worker certificate, they have the certificate of sponsorship. Some applications are sometimes refused. So don't take it for granted. We are here to provide this service, and best of it all. Now, employment law, we specialize in employment law. I always say that if you have been unfairly dismissed, if you have worked for the employer for more than 2 years, then you have a claim to unfair dismissal. If you have had unfavorable treatment at the workplace because of your protected characteristics, because of your color, which is race, I say that when we talk about race under Section 9, we are looking at nationality. In fact, you can be a British, another person can be a Ghanaian. That could be the basis for discrimination. You can even be a Polish, white. Another person can be English. That is under nationality. Two white people discriminating among each other, between each other. We are black, Caribbean, and then from African origin. Two black people discriminating amongst each other. Look, this is deep. So discrimination is not just about the color. In fact, there can be discrimination between two white people. Go and check Section 9 definition and what is listed as a protected characteristics. So if you have had any problem at your employment place, CITI Law Solicitors is here. In fact, those of you who are even employers, if you're having problem with employees and you need advice, we are here to provide that support. Family law, I always say that when we talk about family law, we have accreditation. We are the apex of the practice, because to have accreditation, it means that you have immense experience and knowledge to be granted that accreditation. CITI Law Solicitors is family law accredited. So if you have any divorce matter, if you have any non-molestation order, occupation order, whatever it is, domestic abuse, any of all these family law issues, and you are looking for strong and knowledgeable lawyers to assist you, this is where to come to. Personal injuries and clinical negligence. Look, if you have an accident at the workplace, I think it's last week or last week, I've done so many of the topics and now I've even lost track of them. I don't know whether it's last week or last 2 weeks we had a accident at the workplace. I took my time to explain to viewers so much about their right and the kind of compensation that they can claim. Commercial disputes and civil litigation. It's another strong area that we specialize. If you have a company owing you, if you are giving the money to company for a service that they have failed to deliver or to provide it, and they are keeping your money there. Recently, somebody phoned me and he said that the company whom he has given a description of the product that he wants from them is now saying that because he has paid a deposit and he has refused to accept that product, they could have sold it to another person, and because of that, they are keeping his deposit. And my question is that, look, if you look at the Consumer Rights Act 2015, it makes it very clear that one, a good has to be fit for purpose. It has to be of satisfactory quality. It has to be as described. The description of the product they are giving to you is different from the one you are professed to buy from them. It is not your fault. So that description fails. So you have a right to refund. So this is not a case that you should keep your deposit. If they couldn't sell the product because you kept deposit on it, that's their fault. It's nothing to do with you. So guys, if you have any of these commercial dispute or civil litigation problems, don't go far. City Law Solicitors, we are here to combine the consumer law and commercial law to assist you. So please, don't look far. Media and entertainment, we also assist. We have lawyers who have also specialized in this area. If somebody wants to make a claim for libel and all those stuff, we deal with all this. So it's been amazing having you on board tonight. And before I go, I want to acknowledge Michael Atta. It's a great work. I have Kobena Atta Kakra Forsen, who is also watching. I have Yeroma, salam alaikum. Alhamdulillah. Good. I have King Ebenezer Caesar, who is watching, and John Obriyabwa. Thank you all for coming tonight. Sadly, I'm coming to the end of the show. A quick announcement. On Thursday, MC Chaka will be here. We'll be having this program in Chi, and then we'll take our time to explain every single thing that I have described in English here tonight. So please, all of you, I'm giving you special invitation to join us on Thursday from 9 p.m. onwards, where we'll take our opportunity to explain all these things in Chi for our brothers and sisters who need this help so badly. Don't hide corners and weep. Let us use the law to assist you. One thing I know is that in this country, the law works sometimes very well if you know what you are doing. Okay, the law works very, very, very well if you know what you are doing. So I want to thank all of you for joining us tonight, and God richly bless you. God bless you. Thank you. Bye-bye.